43 Madras 529, 536 PC. In re. The Initiative and Referendum Act, 1919. AC 9935 Mangal Singh Vice. Union of India, 1967. 2. SCR 109, 112, and in re. The National Prohibition Cases, 65 Law, EDN 994, referred to Victoria, Vithacorn, Monwealth, 45 ALJR 251, distinguished. Don John Francis Douglas Leonage Ors v. the Queen and Rana. Ening his case, 965 AC 1072, held inapplicable. Section of 2 of the Constitution. 25th Amendment Act is valid. 625, 626. A and Wandam to the Constitution cannot become invalid because then Stutlan authenticity by legislatures to fix an amount or to specify the principles on which T-amount is to be determined instead of fixing the compensation or spec 1151 the PRMC1 pills for determining one compensation. All that the amendment has done is to negative the interpretation put by this court on TC unapt of compensation, whether a particular law fixes an amount, makes illusory, or one's otherwise a fraud on, or denying the fundamental nangdong to receive an amount specifically conferred by Clause 2, 48 Supreme Court Reports, 1973, sub PSC, will depend upon the law when made and is tested on the basis of Clause 2. The possibility of abuse of a power given by an amendment of the Constitution is not determinative of the validity of the amendment. The new Clause 2R, excluding the application of Article 19(1) to AI, all referred IC in Clause 2 of Article 31, is merely a restatement of the law laid down by Fifth Court after the Constitution came into force. Bank of Toronto v. Lambe, 1887, Volley, Torsen Appeal Cases, 575, 586, 587, and Siddhabati Debianar v. State of W.M. Bengal Honor 1967, 2 SCR 949 referred to. Article 3 IC included by Section 3 of the Constitution 25th Amendment Act is valid. Thought is saved by Article 31C is a law IEA law made by a competent legislature. And since the article comes under the specific heading, Right to Property in Pan 3, the law must involve right to property. The effect of the first part of Article 31C is the same as if a proviso had been inserted below to Article 13.2, or each of the several Articles 14, 19, and 31, excluding their application to the particular types of law mentioned in Article 31C. If the law docs not genuinely purport to give effect to the specified directive principles, it will not be secure against the challenge under Articles 14, 19, and 31 TO. 627, 628. Article 31C docs not prevent judicial review. What the court will have to consider is whether it is a law which can reasonably be described as a law guying effect to the policy of the state towards securing the aims of Article 39B or C, that an issue which is distinct from the other issue whether the law does not give effect to the policy of the state towards securing the said aims. A law reasonably calculated to serve a particular aim or purpose may not actually serve that aim or purpose, and it is this latter issue which is excluded from judicial review. In that view of the true nature of Article 31C, it cannot be said that the amendment is invalid. Point 29 to 631. Biotheranis Valenois 343, U.S. 250, Charles Russell v. the Queen, 188, VUI. Appeal Cases, 829, 838, 840, and Attorney General v. Queen Elianens, RTMCR Co. 1878-3. Appeal Cases 1090 referred to. The Constitution 29th Amendment Act is valid. 632. The argument that unless the acts included in the 9th Schedule related to agrarian reforms, the protection of Article 31B will not be available, has been rejected by this court previously. The VCNTY 9th Amendment is ILOT, different from several similar amendments made previously by which statutes were added from time to time to the 9th Schedule, and whose validity has been upheld by this court. 6.2 NB. Fayib Hoy, Assistant Collector, Thana, 1965. ISCR 636 referred T.J. Khanna. The Constitution. 24th Amendment is valid. The first part of Article 31C introduced by the Constitution 25th Amendment is valid. The second part of Article 31C viz. And no, H1. Fee containing a declaration that it is forgiving EFF secto such pool. TC1 hall be called in question in any court, and the ground that TT does not give F. To the sticks policy is invalid and therefore has to be struck down. The Constitution 29th Amendment Act is valid pp. 759-760. Kesavananda plus tildrala, colonna, J. 49, Article 368, before Constitution tervi. NTY 4th Amendment Eon LDO. Not only the procedure for the amendment J of the Constitution, and also confers the power of amending the Constitution, ASU 757. The words in Article 368, "The Constitution shall stand amended in accordance with the terms of the bill," clearly indicate that the article provides not one NCRCly the procedure for amending the Constitution, but also contains the power to amend Article 368 by the very nature of